Namaskar, hello and welcome viewers. You're watching this special presentation of Sansad TV, Bills and Acts, where we analyze bills that impact you, acts that empower you and programs that matter to you. I'm your host Kriti Mishra and today the spotlight is on the Insolvency and Bankruptcy Code. Insolvency is a situation where an entity is unable to repay its outstanding debt. In 2016, at a time when India's non-performing assets and debt defaults were piling up and older loan recovery mechanisms such as the SARFAESI Act, Lok Adalats and debt recovery tribunals were seen to be underperforming, the Insolvency and Bankruptcy Code was introduced to overhaul the corporate distress resolution regime in India. It created a time-bound mechanism with a creditor-in-control model as opposed to the debtor-in-possession system. And for deeper insights on the code, I am joined by very illustrious guests in the studio. Joining us, Justice Ramalingam Sudhakar, President of the National Company Law Tribunal or NCLT. Also joining us, Dr. Sasmit Patra, Member of the Upper House of Parliament and distinguished lawyer. Welcome to Sansad TV, both of you, and thank you so much for joining us.
Good afternoon.
Good afternoon, sir. Justice Sudhakar, allow me to begin the program with you.
Thank you.
In last 9 years, IBC has helped resolve debt in 26 lakh crore rupees. That is massive. And also the fact that IBC has emerged as a key pillar of corporate discipline and ensuring corporate discipline in the country. How do you see the role of NCLT and particularly IBC?
Thank you very much. To begin, I should say IBC is a very wonderful legislation passed by the Parliament. I am very proud to say that I am handling as a President the adjudication process and managing the NCLT ecosystem, which has shown a new facet to corporate governance. NCLT using IBC framework has emerged as one of the most important mechanisms of corporate governance and amongst the most effective in the field. The financial markets revolve around orderly cycle of lending and recovery to sustain healthy corporate growth, which in turn reflects the GDP of the country. A decade ago, defaults were rising exponentially and the system was burdened with high NPAs and the endless litigation under earlier laws such as Sick Industries Companies Act, Debt Recovery Act and SARFAESI. These adjudicatory process yielded limited results. With the IBC reform in 2016, it brought a sea of change in handling proven debt and default. IBC empowered financial creditors, FCs, as well as operation creditors to initiate proceedings for insolvency resolution in a time-bound and structured manner. Its effectiveness was evident from the moment an admission order is passed and an interim resolution professional takes charge. One singular factor that can be attributed to the success of IBC and the adjudication by NCLT is a large number of cases that are being withdrawn both at the pre-admission and post-admission stages. The number today are as follows. I stop here to give the figures because in this present day, everybody looks at numbers, data and how an adjudicatory body performs. Just for the record, 30,310 cases were settled prior to admission, covering underlying default of 13.78 lakh crores till December 2024. Post-admission, 1,314 cases have been settled and 1,919 cases under 12A withdrawal till June 2025. This, I would firmly state, is corporate discipline. As a result of this, the NPA started declining across the banking system. The gross NPA has fallen from about 10.9% in financial year 17-18 to roughly 2.3% today. The net NPA has fallen from 5.7% to 0.5%. This is a remarkable achievement for this country and we should be proud of that. All that comes out of extreme discipline in the corporate governance. Further, corporate discipline is also reinforced during CRP through operation of Section 29A and 32. The erstwhile management responsible for driving the company in distress is barred from bidding or acquiring the control of the company with some exceptions. The promoters and directors of company are not granted immunity from criminal proceedings and offences committed prior. Therefore, this gives a deterrent that when IBC is invoked, they have to be very careful about how they handle their company. There is another factor which is very unique in IBC is that a term called PUFE, PUFE transaction, it is preferential, undervalued, fraudulent. This is another important facet of this law which has brought in discipline in the corporate world. Now, we do not rest with just certain data which we collect out of our performance. The regulator, IBBI, caused study of the impact of IBC and adjudication by NCLT by a research undertaken by Indian Institute of Management, Bangalore and Indian Institute of Ahmedabad. These two reports are reflected in the IBBI website, also sometimes in our website and in their monthly newsletters. The impact of this study by IIM Bangalore says that between 2018 to 2024, that is the period which is covering IBC, the proportion of loan account, what is loan account is something which the corporates take from banks, financial institution. When it becomes overdue, default, then NPA, then comes the filing of a case before NCLT. So that started moving from overdue to normal by impact of IBC by bringing in credit discipline across the corporate world. So the key answer is directly and indirectly, IBC, when it is implemented by the adjudicatory authority, the corporates tend to fall in line, bring the debts overdues into normal category, thereby avoiding litigation at the threshold.
Right.
Now, I said earlier, cases are withdrawn earlier before it crosses the admission stage because the fear of losing the company becomes very important to the stakeholders. So, they withdraw the case, which means they settle, and the banks and the financial institution get the recovery which benefits everybody. That is what I call as the ecosystem becomes vibrant. Last 30 years has proven, there has proven corporate distress and indiscipline. In the last few years after IBC was promulgated, there is better if not best corporate discipline which is evident from the reduction in the average number of days the loan account remains overdue category. This is another facet which has been studied. From 248 to 344 days of loan remaining overdue, it has now come to 30 days to 87 days, which means suppose you have a credit card. You know that all of you use a credit card, it becomes overdue, then they start interest, they start sending messages. In fear of having some issue being raised against you because of the default, what you do? You pay some amount upfront, you try to settle the amount, you pay up the credit card. So then your dues come to normal. So this is what is happening in IBC ecosystem. Big creditors, big debtors who owe to the banks, the moment they realize that they are overdue on the debt, they start paying up and bringing the debt to normalcy. So this was also studied by IIM Bangalore. The improvement in this category of bringing from debt to the normalcy is improving the credit culture of the country, and also it shows that the corporate discipline which is happening in course of time. The deterrence that is created by this law is most important in corporate governance. But then having said that, NCLT is working in a transparent, predictable and investor friendly. I say so because when we admit to CARP process, there are various people who are interested in taking over the corporate in distress, and they give a resolution plan, and the company which is in distress does not get dissolved or liquidated. It becomes with a new avatar, which I will be dealing separately. Why this is important is, in a country like India, we cannot allow big corporates in distress to just go dissipate and get liquidated. One of the methods which is important in the IBC ecosystem is we have to resolve these companies and bring them back to life. Now, the number of default cases is there in my record. You can see the number of cases which have been filed. We are posting it on our website. Now, why this resolution of the debt and default is necessary is because if India wants to have the vision of Viksit Bharat 2047, then all these distressed corporates should be resolved by judicious method, and it should pass over to in the new avatar to the next promoters or whoever wants to take the stakeholders, making it very clear that even if you fail, the company does not get liquidated, it does not get dissolved. You still have somebody who's giving a hand to pull it up, the workers get benefit out of it. There are so many, this ecosystem is very big. In fact, I was so surprised to see after this IIM Bangalore and IIM Ahmedabad study that what was thought as a simple law to take up insolvency, it's not just an ordinary law, it's a rainbow effect on so many facets of human life. You have to read it to understand, but I can't give you in a short moment so much of material. So that will be on the first question which was said, why is NCLT a key pillar in corporate governance and what discipline it has brought about?
Right, sir. Point well taken. You've made very, very legit points, sir. Dr. Patra, coming to you. The government has brought in 6 amendments and 122 regulatory reforms for the IBC. As a parliamentarian, how do you see the impact of IBC on Indian economy?
As His Lordship has already mentioned, the impact of Insolvency and Bankruptcy Code, as was envisaged by the Parliament, has been truly transformational, especially in unlocking all the liquid assets that had become non-performing assets and to bring them back into the economy. Because the idea of Viksit Bharat and to become a $5 trillion economy would not be possible unless IBC and NCLT was to actually work and ensure that that fund actually comes down back into the system and ensure that the working organizations which are on the brink of bankruptcy are again as a going concern brought back to life. That is something His Lordship and the entire NCLT and IBC has been doing. I'll specifically talk about those 6 or 7 major interventions that have been done as amendments by the Parliament over the existence of IBC. The first was in 2018, if you were to look at it. Presently, it was the Amendment Act was 2017. It was deemed commencement from 23rd November 2017, which was inserting ineligibility criteria. Now, many frivolous people had come in who were trying to stall for various reasons. Shortage of time, I'm going to quickly go through. But what has really happened with this intervention is that all those who are eligible and ineligible are now defined. The second amendment came, which was commenced from 6 June 2018, where it was carved out home buyers as financial creditors. There are many home buyers who are running helter-skelter. Under Section 7 of the IBC, it provided for financial creditors, but only referring to those who were basically banks or financial institutions. But home buyers were brought in and thresholds were fixed, where they became a part of the COC.
Right.
The third, which became important, was CIRPs should be completed in 330 days. The timelines were fixed. It reduces uncertainty. The fourth amendment, it clarified as to who qualifies as financial creditors. Home buyers thresholds, provided statutory immunities and clarified interim finance. That has really helped to bring about greater amount of transparency and sustainability. The fifth one, it temporarily suspended initiation of CIRP for defaults arising after the 25th March 2020 COVID period.
Right.
Many of the organizations went south. At that point of time, it became very difficult for them to recover. And that is why it protected firms from immediate insolvency because of that matter. The sixth was introducing pre-packaged insolvency resolution process for MSME sector. And that protected and ensured that faster consensual resolution for MSMEs came.
True.
The seventh was various definitions and cross-border enabling provisions came in. That ensured greater clarity on cross-border, which is one of the key areas for Viksit Bharat. And finally, in 2024, we had sections across CIRP where avoidance transactions, admission timelines, digital filing, and NCLT paths were properly defined, which helped for faster admissions, clarity on avoidance, and also streamline the processes.
Absolutely. While you talked about sustainability and transparency, I would also like to apprise our viewers about this very important data. Data shows that the average recovery under the IBC has been 30 to 35%, which is much higher than 22% under SURFACI, 7% under DRT, and just 3% under the Lok Adalats. Justice Sudhakar.
Can I just interdict here for a moment?
Yes,
there is another facet of this data which you have shared. Of course, we have put it on our website also. Very interestingly, if you see the number of cases which were handled by DRT or under the SURFACI Act to recover this amount of 22% or whatever it is, and the number of cases NCLT adjudicated to get the 30 to 36%, you see the figure is so large that it is like 1 lakh cases to get the 20%. Right. Whereas we deal about 1,200 cases to get the 30 to 40%. I want to say this effectiveness of IBC is with less input, you get more output.
Right.
This has not been factored in by many of the critics of IBC and NCLT, that what is the time taken by adjudication of 1 lakh cases by DRT or 50,000, anything for that matter. Such a high volume is being adjudicated, and what is the result? What is the manpower involved? How many courts are involved? How many lawyers are involved? So what is the overall cost to recover this 20%? What is the overall cost to recover what NCLT has recovered?
Right.
That is one data which nobody is willing to accept, that performance of NCLT far outshines every other method of adjudication in resolving issues.
Absolutely, sir. Thank you so much for sharing that perspective with us. But as you said, that input is less, but output is enormous. But sir, there are challenges as well. What are the challenges and how do we address them?
So this is one thing which I have been time and again requesting honorable parliamentarians when they ask questions about the working of NCLT and how it is performing. They are very keen to observe this institution, the number of questions in every session asked, and I personally look into it and give my humble response to the parliament so that the honorable minister concerned can respond to the honorable members of the parliament. But the very simple solutions which I have suggested, I know it's taking some time, is like this. When NCLT was formed, it was on the basis of the Madras Bar Association case, where cases from Company Law Board and the High Courts were transferred to NCLT. 62 members and 1 president. But when IBC came in 2016, a separate vertical for IBC cases was not formed, no courts, no judges, no infrastructure. So what is happening is, you split the bread between 2 mouths, then both are hungry. You spread I hope you understand now my way of expressing anecdotes.
Yes, sir.
So you split the bread and give it to 2, both are suffering, they are not hungry, they are hungry. The company cases also are not getting its prime. IBC, of course, with my endeavor and push, has shown remarkable result, I can say for sure, because if you compare BIFR, that data is now there, I will try to put it on my website also. In the last 9 years, 1,407 cases have been, plans have been approved, which means corporate has been resolved. After the 4 lakh crores is the amount involved in the resolution plan. These figures are very important. 3,763 cases where CDs have come out of some sort of insolvency resolution. So it is not NCLT that NCLT is disposing of cases like any other adjudicatory body. It is giving life back to these corporates. So that is the most productive nature of this law and the adjudicating process. We also do one other important factor. It is called weeding out process. Some companies are dead. Some cannot be revived. Well, I'll tell you one classic case of Hindustan Photo Films. I ensured that after 30 years nothing happened. I passed an order to dissolve the company once for all, because it's more a liability on the union government than to keep it running and wasting more money on a debt capital. So that also happens through NCLT. So the biggest challenge is there should be a separate vertical for IBC, and NCLT is running on contractual staff. There is a huge attrition, so I am facing a big problem on infrastructure and officers. All of my officers are from a deputationist, so they go away after 3 years. There is no institutional memory. So this gives rise to a lot of complications. You know, post-COVID, there was no president for some time, and many things went bad down south. I won't say south, sorry, because I am from south. So when things went bad, but then I had to restore it. There are still some glitches, but I wouldn't say it's alarming like other institutions. There are bigger problems everywhere. But the recommendation I have given to the honorable members of the parliament is, the Honorable Supreme Court in a committee has recommended for all courts what is called as National Court Management System. I happen to be part of that committee along with some of former judges, present judges of the Supreme Court, which gives the framework as how to court should be established. I would suggest, it is my humble opinion, that NCLT court should come within those parameters of the court management system, so that the court system can establish in a very proper framework and not be done in a slipshod manner, which is happening here. In fact, from 2019, 2 courts in Delhi are running half a day because there is no court, which I have been highlighting again and again. Even if you take the lakhs and crores of money that is recovered or coming back into the system, sorry to say that, coming back to the system, it's not recovery. If that is taken into consideration, a small percentage is given to NCLT, it will do wonders. Right. And that is what is my suggestion.
Dr. Patra, I hope you've taken note of what Honorable Justice has said.
Kriti ji, जो हिंदी में कहते हैं ना, मैं भुक्तभोगी हूँ. The fact is that I personally appear in NCLT as well with a caveat, but the fact is that I have seen the struggles that His Lordship has to bear, because there are times when there are rains and 2 courtrooms become flooded. It is our responsibility as a parliament to ensure that the tribunals and the courts are provided the best infrastructure, and we will work towards it, to providing the best infrastructure possible to His Lordship and this entire team.
Absolutely, point well taken. On that note, let me open the floor to the questions of these young budding lawyers. Please go ahead.
What is the role of National Company Law Tribunal in the new Insolvency Code?
Actually, to be very frank with you, these amendments have come not because of just like that. See, I have a very healthy relationship with the chairperson of Insolvency and Bankruptcy Board. He takes the work very seriously and meets me very regularly and asks us, not only me, to the members, what we do is we hold regular colloquium, which has never happened. I was a judge in Madras, in Jammu Kashmir, in Manipur, except going once or twice to Bhopal. Otherwise, we don't have regular colloquiums. But I created this colloquium as an in-house training once in 3 months. The reason is this: there are technical members and judicial members coming from different facets of law or different fields like banks, income tax, government and things like that. but not all of them are tuned to that. My role in doing this colloquium is to imbibe into them the concept of this IB code and the companies, like I do it for both, and then do brainstorming sessions, make them ask questions, what is the problem they face. In all this colloquium, the regulator is a part. So there we say, we share experiences like how the parliamentarians express that in the public podium.
Right.
So we get inputs from all members, then IBBA takes down that and starts amending and suggesting amendments. That's how it has come. One thing I'll tell you what happened is, earlier when a plan approval used to be passed, it will start from the history, geography of the case, and the volume of the plan will be so big. Even now it's quite voluminous, but I wouldn't say that big. But what I did was, I created a template and asked IBBI, sir, whether you are acceptable to this. Then I took input from all my members and they agreed. And now there is one form called Form H, which is filed along with the plan, which gives all data which is not in contest. So there is no need. It is essential, but not in a matter of contest. But then the court will adjudicate on the issue which is to be adjudicated. So that will form part of the next part of Form H. So this reduces the timeline for people preparing the prelude to a plan approval order. So like this, now the next one which I have suggested recently is what is called as avoidance applications, where people are forced to bring back the money which has been transferred from the corporate debtor prior to initiation of CRP. So it's a very big process. Lot of money is involved in that, but due to lack of judges or courts and time, we are unable to take a very effective steps. So we have suggested we simplify the process. Okay, it is for the government to increase the number of courts. So I can only plead. But what can I do from my side? No? Right. I can do something. So I have suggested a simplified method of creating again another pro forma for this avoidance transaction so that the process is simplified.
Right.
So this is what we call as case management. Now every amendment which is now coming, which they have suggested is based on an interaction between NCLT and IBBI.
Right.
And also we take sometimes input from the government, of course. They also are stakeholders. So this comes as a part of amendment. Of course, the parliamentarians will take a call on that, whether it is justified, whether it is lawfully correct. This is up to them. We can only give our honest and humble opinion to them.
Right.
That's how it is.
Right, sir. I have paucity of time. We'll take two questions together. Please go ahead. Introduce yourself.
What are the key structural problems in the current IBF that this amendment directly aims to fix? I mean, litigation, delays, or something else? And will the responsible body, I mean government, ensures the proper execution of this amendment?
Delays. Second question, please.
So first of all, you and your whole team, the whole NCLT is doing a great job trying to improve the Indian economy whatsoever. But my question goes to the psychology behind how you decide the companies that are actually willing to improve their work and to go back to normal, and the companies that are not willing to put any work into the companies and trying to just get dissolved whatsoever and not willing to do the work.
So two questions, delays and intent.
Okay. As far as delay is concerned, as I said, there is only two simple solution to a problem. One is if the numbers of courts are increased, which I have requested even as a temporary measure, additional courts are there, then it can address the delays, because the kind of adjudication which NCLT does is quite stupendous. In fact, two cases I can quote. If you can read the decision in China Development Bank passed by the Honorable Supreme Court, you see the nature of litigation underlying in that case. It was passed by a technical member of NCLT. It has gone to NCLT, which was reversed the order of the NCLT, and the Honorable Supreme Court upheld the order of NCLT. So which means it's a very complicated issue on interpretation of documents between parties. So this takes some time. There are a number of litigation before NCLT where multiple documents are tested like a suit in original sites of high courts. So if members are able to adjudicate that many number of IAs, would it not require that number of courts also for that? So that is more important. People should understand it is not just debt and default, admit there's a plan, approve the plan. That's not working that easy. You have to see the quality of orders, the type of adjudication we do. If you read through that, all criticism about delay will vanish. There are people are making complaints of delay without understanding what exactly NCLT is doing. I am very sorry to say that, but there are criticism, we will take it. But they do not understand in what condition and in what capacity we are performing. That's the answer.
Sir.
The second question, of course, you said commitment.
Yes.
Would you like to answer that?
No, sir.
Okay, your lordship. Explained, which was the companies that are actually willing to put more work into them and to get to the normal, and the companies that are actually they do have potential, but they are not willing to do any work into it, and you just dissolve it.
I'll tell you that answer it is already answered in many of the NCLT adjudication. I'll tell you how. Companies who are not willing to go forward and they have failed miserably or they have dissipated the wealth, it goes back to some other company. You have seen major steel companies, power companies, everything is there. It's all in domain big. So 12 bad companies were referred to and most of it has come back. In fact, one of the companies which couldn't do, I passed an order, it's called JP Infratech, which is subject matter of appeal. The 20,000 home buyers got their house.
Absolutely.
That's one of the biggest compared to China. Evergrande went into liquidation. On the same period, we approved a plan.
Yes.
Of course, there are certain issues always, nobody is, doubt-free or fully capable of performing. There are some issues in that we can resolve. But priority-wise, if you see, even in real estate, the number of cases it has been resolved by NCLT is higher. What is pending is less. So there are some criticism on that. But the point is, NCLT can revive all companies who are willing to come through the process. That is the most key. The other one which you are saying is, there is an option even for MSMEs and people like that to come back and give a proposal which is called PRP process.
Yes.
We have passed some orders in that also. The only reason there are not many takers on that. If they come forward, NCLT can give a considered resolution even to those who are willing to come with a fresh life to their own companies. That can happen. It is happening also.
That's a very important assurance. Yes, Dr. Patra, please go ahead.
Just 2 minutes.
Yes, please go ahead.
Just to supplement what His Lordship has said. Practically practicing it, I'll give you two quick examples. 2 days back, I was appearing on a matter in NCLT. It was a company law board matter that started in 2011, even before NCLT came. And to dispose it off, can you imagine the amount of work that NCLT took? And this is again, it was passed, it was disposed of, and the order took more than 40 minutes to dictate. So you can imagine something. So sometimes we look at NCLT and IBC from the perspective of 2016 and after. We forget that there are hundreds and thousands of cases of company law board, which is also a part of the NCLT, but we only look at IBC. All of them are also running. Every Tuesday, the company law board matters are actually a part of that. Second, which His Lordship said, home buyers. You look at 302 item, only one matter. There'll be connected matters more than 60 to 70, which basically means it's not one matter. There are 71 matters. And that is where the challenge lies, to increase more capacity, provide more additional courts, and more importantly, provide infrastructure.
Absolutely. So it is about balancing judicial oversight and also economic pragmatism. On that note, I'm completely out of time, by the way, but thank you so much, Justice Sudhakar and Dr. Patra, for sharing this perspective with us. And thank you so much for joining us.
Can I just add only one small issue?
Yes, sir.
See, IBC is a very important and landmark reform. See, 2 reports, one by IIM Ahmedabad and IIM Bangalore, have given a very important focus. But what the impact of this study is, after resolution by NCLT, the companies have successfully undergone an average of 76% increase in sales, 30% increase in capital expenditure, 80% improvement in liquidity within 3 years, employment and wages expenditure grew by 50%. The market cap of the resolved companies grew from 2 lakh crores to 6 lakh crores post resolution place.
Imagine.
So this is the most important thing that everybody has to understand. Therefore, what should be done is this ecosystem of IBC should also go to private individuals, so that India as a whole develops at a very structured government with corporate discipline, personal discipline in finance, and it will become a reality for Viksit Bharat.
Absolutely, and
Thank
as
you.
India aims to become a $5 trillion economy. On that note, thank you so much for joining
you.
us.
Thank you.
Well, viewers, that's all we had for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye for now from my side.
To watch more programs of Sansad TV, subscribe to our YouTube channel and don't forget to like and share them.